Greetings from Team Indian Medical Association. I am Dr. K. Agarwal, incoming President of Indian Medical Association. Welcome to our weekly show, and today is a special show because we have an expert with us. And normally we have this webcast every Thursday, but this we are having a special show on Monday 3 to 4 p.m. extra. And with me joins Dr. R.N. Tandon, who is going to take over as the Honorary Secretary General on 28th, and I take over as the National President. Today we are going to talk about an important subject, child sexual abuse, and with me I have Dr. Shekhar Seshadri, who happens to be my colleague mate in Deshbandhu College, though we were in different batches, and he also happens to be my year mate in MBBS. He joined Maulana Azad Medical College, and I went to Wardha Sevagram for joining MBBS. He is a postgraduate in psychiatry from NIMHANS, Bangalore, and currently he is the professor and head Department of Child and Adolescent Psychiatry in NIMHANS, Bangalore. So welcome to our show.
Thank you very much, Dr.
Now, child sexual abuse is an important subject to us. In 2013, India organized a Confederation of Medical Associations of Asia and Oceania conference on the subject, Stop Child Sexual Abuse. And after that, Indian Medical Association now is the nodal medical association of all the Asian countries as far as the subject of CSA is concerned. And we were talking about the subject of CSA, and initial survey showed us that doctors are not aware about the child sexual abuse. So we created a sutra. On that sutra, we would like to make our discussions. When I say sutra, means that a doctor has to remember so many diseases, impossible for him to remember every aspect. So we come out with the sutra. Say sutra is formula of 10 for how to revive a person, formula of 20 for how to prevent a heart attack, formula of 2 for how to prevent an asthma attack. So similarly, we try to come out with formula of 3 for HIV understanding. So in child sexual abuse, means age 18, we came out with child means 18, sexual means the parts which are normally exposed in a swimming pool, abuse which can be assault or which can be distress or evident or suspect is common in both male and female boys and girls, preventable and punishable to both doctor if he doesn't do examination in time and to the person who has done it. Acute medico-legal emergency. This is how we try to create as a sentence so that every doctor remember all aspects of it. Now we are now going to discuss on these lines. When I say child, why the age 18?
I think one of the issues that we need to keep in mind is that internationally people are trying to reach a common definition or a consensus on what childhood means. And there were variations across different sectors. Some took it at 16 and some at 18. And so if you look at driving license or voting rights, for example, or the older laws under which consent was not a valid argument to have sexual relationships with a minor and so on. In order to place all this together, now the new Juvenile Justice Act has clearly defined childhood as ranging from 0 to 18. And this is more or less in consensus internationally of how childhood and adolescence is defined. This is one issue that I want to table. A related issue is also that where children are concerned in the context of child sexual abuse, children as young as those in the preschool age group, even children as young as 18 months or 2 years old, are liable to abuse, and adolescents as well. And at some point of time later in this webcast, I will allude to some of the complexities around adolescence and sexuality itself, and how the new law, which was promulgated in 2012, this is the Prevention of Child Sexual Offences Act. If there are two 16 or 17-year-olds in a consenting relationship, how does that play out? And what stance does the medical fraternity take on the nature and the emergence of adolescent sexuality? So there are various nuances to the age component itself. And the last thing I want to say as far as children are concerned is the child sexual abuse, as you rightly point out, is a child and childhood issue. And in a situation where children and adults' relationship is constructed on a culture of obedience, and if you add to that the culture of denial and the conspiracy of silence and the culture of impunity, the problem for children become that much more. Which is why child sexual abuse is no longer a hype. It's a reality that we have to contend with.
Okay, we will come back to some of the dilemmas faced in legal problems and what are the legal things needs to be taken care of. And then say sexual abuse. How do we define sexual abuse?
Yeah, so child sexual abuse is not restricted to sexual assault. So child sexual abuse is not equal to rape, contrary to what a lot of people believe. In fact, the new law clearly defines all the elements. So we need to understand that child sexual abuse can be contact or non-contact. And non-contact abuse includes exposing children to pornography or taking pictures of the child or engaging the children in sexual talk for the perpetrator's own pleasure and for his or her own purposes. Contact abuse itself can be genital or non-genital, and genital abuse itself can be penetrative or non-penetrative. So we also need to understand when we look at some of the prevention programs which focus unfortunately a lot on this good touch, bad touch issue. Sometimes a bad touch can feel good. And it really depends that all sexual abuse is not necessarily coercive or hurtful. Some of them, many of it, is perpetrated in an atmosphere of seduction and inducement, and the child is not able to differentiate that. So this whole inducement process makes a lot of difference in how traumatized a child feels. And so we need to understand this. The new law has added another dimension which is known as aggravated abuse. That is, if abuse occurs in a situation, in an institution with a person who is in charge of the caretaking of the child, it invites a harsher penalty, and understandably and justifiably so.
Okay, so when we come back to child sexual abuse is common, evident or suspect. Because now POCSO Act says that if you are even suspecting, because that's a situation with us, that even if child sexual abuse is in your differential diagnosis, you need to inform the police.
Right. Now,
so evident can be physical, psychological, so all those things we need to answer.
Well, there is a pyramid to this. Now, obviously the highest index of suspicion is if a 14 or a 15-year-old girl is pregnant. Or if someone has genital injuries, or if a child discloses, then the evidence is hard. But there are a whole sequence of evidences such as a child demonstrating sexual behavior, or a child manifesting specific avoidance of certain people. But equally, it can be children who have symptoms like school refusal or bedwetting or nightmares, or sudden onset of cranky behavior. And on the other hand, it may have children who do not manifest any symptoms because they've either been threatened or they are resilient. So there's a whole range of this pyramid by which we understand what are the hard indicators of in history, and hard indicators when you examine the child as well. Now, the law therefore talks about mandatory reporting. Mandatory reporting has its own issues, and we are in the process of discussion on mandatory reporting, because a child in a family may plead with you to say that we are not prepared psychologically to meet with the demands of mandatory reporting. You will destroy the family.
As on today, the reporting is mandatory.
It is.
Okay. And as on today, even if you are suspecting, if you say indifferential diagnosis, it can be asexual abuse, you need to inform the police.
That is what the law states.
Oh, I'm not talking about the law.
But there is a position that the mental health fraternity is taking, which is that mandatory reporting is not a one-off process. It is a process. That is, we need to appreciate the hesitancies of the family and the child.
I want to debate over this. See, up till now, we were taught a lot about social science.
Right.
I remember that all my life we have practiced where a girl has taken, say, 4 tablets of Alprex. She would come to us. Okay, no normal person would take 4 tablets of Alprex. It has to be with the intention of committing suicide or threatening the family.
Right.
And we never used to make MLC. We used to get it written by the family. We don't want medical legal care. We don't want this. We don't want this. And we used to help the family on a social ground.
Right.
And we used to be with the patient. But when a super VIP case happened, and one of the top hospitals of the country, and the person was found with this drugs, and the hospital tried to save him, and they all ended up in the jail. They had to take bail, and they're still facing the case.
Right.
Because the law is very clear. You have to inform the police. So if I am going to, in a mandatory reporting, if I am going to help the family, today or tomorrow, I may end up into the problem.
Yeah, but the point that
So either we change the law.
Yeah, no, the point I'm trying to explain is, the law does not state that if a child reports abuse to you, or you suspect abuse at 17 minutes past 3, that you have to report it at 18 minutes past 3.
Okay. That is okay.
So the only point I'm making is that we need to understand sometimes that child sexual abuse interventions can be as traumatic as the primary abuse itself. And somewhere the balance of this needs to be kept in perspective, because 2 things can happen. A child may tell you, I won the war, but I lost the battle.
Absolutely.
And the whole issue of child protective trial procedures and prevention of secondary victimization that. So what we are advocating is a strong protocol-driven approach to both assessment and intervention of children, so that all the hesitancies are addressed, keeping well within the mandate of the law. This helps a professional negotiate with the child and the family in a manner that all their hesitancies are addressed, they are suitably reassured, interventions are started, and they are assured that the process of inquiry and intervention will be done in a smooth, predictable manner. It is the unpredictability and the multiplicity of interventions that is a deterrent for. Because the child says, I've been interviewed 17 times over and over again. So we are actually looking at what are called as one-stop trauma centers, where the police and forensic investigations, the legal investigations, the medical investigations, the psychological assessment, all of it occurs in a one-stop facility, so that the child has the definitive and a legally sound evidence base to be able to present.
So if you feel that this is something where the policy and the law needs to change,
right,
and if you want any help from Indian Medical Association, take it up, we'll be with you.
We would be delighted for the Indian Medical Association to
all those dilemmas in CSA, give us a draft, and then we can take it up and support your effort into this. We agree with you, but then that's what the law is.
Right.
So therefore, when it comes to corporate hospitals,
Right.
see, when it is a doctor-owned hospital, his approach is different. In a corporate hospitals, there's nothing to report. You don't care. So nowadays, even if a person has taken 4 tablets of Alprest, immediately the police is called. Person is completely all right. So
Right.
people are now hesitating coming to the hospital.
Right.
Now they are calling practitioners at home in such a situation so that they can help.
Right.
But then the law is a law. So therefore, if we feel that we need to have, even for one-step trauma center,
Right.
you can write a concept paper,
Right.
IMA can take it up.
I think
Also.
that what unit is called as, they have paid in certain hospitals.
That's right.
For child sexual abuse victims only, CPR.
It's called the Collaborative Child
Yeah.
Response Unit.
So they are doing that interview and treatment and everything. at
Exactly.
hospitals.
Exactly.
So that is there, and as far as the mandatory reporting, I think world over people are fighting for mandatory reporting because this is leading to more trauma to the child
Right.
and the refusal for the correct treatment.
Right.
That is being needed. Right? Mandatory reporting is already in jeopardy. The people are trying to change it.
So let's go back further. It's common. It's common.
Coming back to the whole issue of the culture of denial, that when many of us started work in the area of child abuse, there was this notion it's a Western phenomena. It doesn't happen in India. Where are the figures anyway? Where is the research and so on? And we found to our surprise that there wasn't any research, and we had engaged at that point of time in some research work. Unfortunately, it was not published research. It was done merely because we wanted entry into educational institutions to do prevention programs. And we were denied entry because of the same obstacles that, there was no evidence and that this was not an Indian phenomenon. And later, of course, there have been large-scale and formal studies by many non-governmental organizations and a major government-sponsored study which was supported by UNICEF and done by the ministry and executed by another NGO. It was a pan-India study with a very large sample, which showed fairly high prevalence rates of child sexual abuse, both among boys and girls. It also showed that, contrary to the myths that many people have, that child sexual abuse is perpetrated by strangers or people with mental illness. In point of fact, most often it is perpetrated by people known to the child.
Almost 90%.
Or yes, to a very large extent. And so it's far more common than people would like to admit or believe, precisely because of this whole culture of denial. But I think the lid has been blown off, and compared to the resistance there was to acknowledge this reality 20 years ago, I personally believe that child sexual abuse always existed. It is just that due to the pioneering work of NGOs and after some of the studies that have been done, we know that it's far more common than we'd like to admit. And though the rates vary...
Any evidence in our mythology? Any example?
Oh, there are plenty of... I'm not able to, to recall offhand, but if you look at the whole phenomena of abuse itself, in terms of punishment that is meted out to children, or if you look at the larger framework of child abuse, part of which is the whole issue of child marriage itself. So there's a whole background and basis to the fact that this is not a new phenomenon, in the sense that it is not a new epidemic that has, suddenly reared its head and made its appearance out of nowhere. That adult-child relationships, the whole issue of power dynamics, because we spoke about childhood, we spoke about sexuality and about how common it is, but the whole issue of gender and patriarchy, about power and domination, and the abuse exploitation connotation, the unfortunate truth is that it is a rather common phenomenon.
Okay, it is punishable.
Well, as I said, the new law is a welcome change, and I'll tell you why. Because if you look at the time, the pre-POXO era, under the Indian Penal Code, we had basically two sections, 354, which was outraging of modesty, and 376, under which the provision was for penile penetration. Now, here's an example of the limitation of that law. There was a defense lawyer who asked for acquittal of his client, saying that the child in question was 18 months old and therefore does not have a abstract notion of what modesty is. And penile penetration did not take place because he used an object or something, and because it didn't satisfy the legal provisions under both 354 and 376, that the client should be exonerated. Therefore, an abusive act is trivialized because of limitations of the law. This is no more the case with POXO, because it has done away with the whole provision for penile penetration. Any form of handling of a child for sexual purposes constitutes, under various sections of POXO, it constitutes abuse. So this is the sea change that has occurred after the law came into being, and this was not a provision in the previous law. The law also makes certain recommendations, many of which have to come into operation yet. For example, it speaks about child-friendly courts. It speaks about the setting up of special courts. Unfortunately, many of these special courts are in the same adult court complex that, so there's a lot of ground to cover. There's also the need for training of the judiciary and training of police officers in child interviewing, and and there are many other provisions that the child must not come face to face with the accuser. The child may not be questioned directly by the defense attorney, but what the defense attorney wishes to know is submitted to the judge, and the judge may conduct the inquiry in camera. So there are these different provisions under the new law to make
Not happening.
a lot of it is not happening but they are moving at a much slower pace than it certainly could be faster.
What about punishable to the doctors? Not examining, refusing, and not reporting.
Well, the POXO does speak about the issue of mandatory reporting, that failure to report.
Failure to report, failure to treat, refusing to
would invite a penalty. Has any doctor so far been prosecuted under that provision? To the best of my knowledge, no.
But even then,
is it likely to occur? Yes.
If they are not knowing, then they are likely to make more mistakes. So therefore,
absolutely,
they must know that they cannot refuse a child sexual abuse patient to attend.
Absolutely.
So therefore, it is mandatory for doctors to. It's like when I say medical legal case, so they need to examine, they need to keep a report, they need to collect all the samples, and otherwise it will be taken up as a efficiency of service.
Absolutely.
The efficiency of service. So preventable, it is preventable.
Prevention has two components. There's so much of focus in schools on personal safety workshops and so on, all of which is good, and the whole child protection policy that many schools have come up with in the presence of CCTV cameras, and I'm not too sure that CCTV cameras and personal safety workshops are the only way to go. They are necessary, they need to be done. But how does one expect a child to be able to distinguish between subtle good touches and bad touches, especially there is no threat of coercion or hurt involved? On the other hand, if coercion is involved, how does knowledge of good touch and bad touch prevent a child or enable a child to actually resist? So I believe that, as do many colleagues and activists who work in the area, that a strong response to child sexual abuse is as important to create a deterrence and therefore prevent it. So I believe that response is equal to prevention is equal to response. And what happens when an episode of child sexual abuse comes to be known is that it generates a whole series of incoherent activity which is not coordinated, and people work at cross purposes. There's duplication of work, and the child is unfortunately subjected to multiple investigations, and this only disempowers the child further and creates re-traumatization.
I would say preventable is high degree of suspicion,
Yes.
and continuous education.
Right?
As per prevention system. Now I come back to acute medical legal emergency. So when I say emergency means you cannot refuse, acute means the child is in trauma, don't ignore it, and medical legal means all the question and answers, all legal formalities have to be fulfilled. Let's talk about it in terms of concept.
I must tell you something very interesting with regard to this particular issue. I cannot emphasize on the issue of the acute emergency more. I think it's a very important point that you're making. Often what happens is that when the police bring a child to us with suspected abuse, and the index of suspicion is very high, the child is in a situation of trauma, but the police are interested in information and investigation. One of the requests often is to help them in getting the evidence and to say that your counseling process can always go on. I wish to make the point that all these investigative processes which are geared towards punishment of the perpetrator, important as they are not more important than the healing of the child. The child's counseling and healing and well-being comes first. Everything else is secondary to that. Therefore, the acute trauma of the child takes precedence, and any legal process has to be predicated on the reassurance of the child. That so, prevention of reoffending, reassurance of the child, reduction of trauma impact, reassurance of the family is our primary objective. Then comes the investigative and legal processes and assisting them in the same, and then the matter may come to the initial parts of the legal procedures in the inquiry could start, but they cannot take precedence over the child's healing and well-being.
And then what about the formalities to be done by a doctor?
There are several responsibilities depending on whether a child goes to a pediatrician or a gynecologist or to a general practitioner, or a child comes to a psychiatrist first. Often what happens...
Male or female, both.
Yeah, it could be both male or female. Often what happens is...
The doctor can be male and female.
Well, there are certain recommendations, sensitivities and sensibilities that come into play. And it is recommended, for example, that if we are talking, for example, about genital injuries, or we are talking about genital examination, that it would be preferable for it to be done by a female specialist.
What if the female is not available?
it can be done by a male doctor, but in the presence
Of
of
a
female friend.
then. To expand on this point a little further, what
And
happens?
can the child refuse?
The child has the right to refuse.
Parents now.
The child has the right to
No,
refuse.
child is 18 minus.
We personally believe that even a child who is below the age of 18 has the right to refuse. There is the issue of taking the consent of the parents. Again, I think I want to emphasize this point to the entire medical fraternity that where trauma is concerned, and especially where sexual trauma is concerned, the matter needs to be treated sensitively as a process. The fact that a child is refusing consent today is because of a certain trauma or a certain discomfort. It doesn't necessarily mean that the child will continue to refuse 2 days down the line or a week down the line. It's a question of, there is also but a sense of urgency, because forensic and medical evidence gathering also has a certain time pressure, because you lose evidence there. There's also the issue that in many cases there is no physical evidence, because that kind of abuse has not taken place. So there's no visible physical evidence. And other cases that there is visible physical evidence and time is of essence. It's a question of how it is explained to the child. And if the explanation is given in a gentle, detailed way where the child sees the importance and the examination is done in comfortable, reassuring and dignified conditions, then usually there is no problem in obtaining an...
The child says no, the parent says no. What to do?
It's a process, Doctor.
No. Suppose a person comes in an emergency, there is a child sexual abuse. The parent says, we don't want reporting, we just want a first aid, we just want a counseling, we just want to be reassured, we don't want police to come, we don't want it to be reported. And say, we know the person, he has apologized, we have removed him from the house.
Again, it's a...
How will you take it up?
It's a persuasion and it's a negotiation process. Let's look at this from the point of view of two extremes. The child and the family are hesitant and refuse for whatever reason, legitimate, not so legitimate, based on anxiety, based on a past bad experience. There could be any number of reasons. Would one get into a dramatic situation to say that I am compelled by the dictates of regulations and mandatory processes that I will do it, and therefore get people screaming and shouting to actually pin them down to examine? To me, this is an assault. It's a travesty on justice. On the other hand, as I have repeatedly said in this webcast, many of these need to be embedded in processes. If the family is allowed to articulate its hesitancies, if you respond to it with authenticity and truth, if you explain that the issue is not about somebody apologizing, it is that other children will continue to be vulnerable for it. This is not to say, you could well turn around and say, it doesn't matter to me whether he goes ahead and abuses other children. I don't want to be drawn into these processes. To which again you respond to say that while we respect your position, what is the extent to which you will take a stand? And the issue is not so much about punishment of the perpetrator. Now that you have come for intervention and for assistance, there are certain provisions and certain regulations which I need to do. Whether you continue and proceed with further processes is your choice. These are some preliminary things that one needs to complete. Often what happens is that the medical team either does not have the time or the patience to engage in this kind of, because this can take several sessions or several hours. There's a certain impatience and a certain sense of urgency. And in trauma, in sexual trauma in particular and in child sexual abuse even more particular, the professional sense of urgency and tension cannot dictate the way that the consultation and the persuasion process is
I'm actually going to divert to another subject. I'm not talking about the psyche of an abuser. Okay. Abuser can be of any age.
Right.
It can be adult, it can also be a child, it can also be an adolescent abusing an adolescent.
Right.
Okay. Suppose an adolescent abuser comes to me, I want counseling. Where does he go? Do we have facilities? Do we have people? Suppose he says, I like exhibitionism, I like to show my links to women. He says, I like to have fantasies with the women's clothes, I like to watch porno movies, I like to share my porno movies with my girlfriend. Suppose he says that I'm obsessed. Do we have centers in India to take care of them? Because now we are talking about punishment, punishment and punishment. We are not talking about their rehab and their psyche. And we are saying that if you do that, but he says, give me injection and stop my sexual drive. So do we really have such setups in India to counsel? We are talking about counsel of the accused. And I'm talking about counseling of the abuser.
Let me address this in an expanded fashion. You would recall earlier in this session I mentioned about two 16 or 17-year-olds being in a consenting romantic relationship.
Which is common.
Which is common. And they run away together.
Which is common.
First, a missing persons complaint is lodged. Then they are discovered, by which time they have already engaged in sexual intimacy. Then a kidnapping and rape charge is levied on the boy, though it was a consenting relationship. And under POCSO, he is put in an observation home as a child in conflict with the law. Now there are three problems here. One is that there is a non-recognition of adolescent sexuality. Second, this approach is gendered because there was no coercion. That, mind you, this thesis does not hold if a 16-year-old, for his own sexual satisfaction, coerces and forces a 6-year-old or an 8-year-old. I am talking about two 17-year-olds in a consenting relationship. And the truth, Dr. Saab, is that if you had to put all 17-year-olds who engage in sexual activity in the observation home, let me assure you that the observation homes in India do not have place. They would be in millions. So let's be a little realistic here. This is one aspect. The second aspect is the context that you're speaking about is of an adolescent who has what is increasingly and recently being recognized as behavioral addiction. Whether it is Facebook or social media or gaming or pornographic sites. And the National Institute of Mental Health and Neurosciences, Bangalore, where I work, runs a specialty clinic called Socially Healthy Use of Technology. It's called the SHUT Clinic, where specialized services are offered for people who have behavioral addiction. Therefore, it's the counseling approach or the treatment approach in a person like this is not to delegitimize sexuality itself. Sexuality itself is not wrong. It is the context that we speak about. So when we work with people like this, we touch on different themes. We touch on themes of health, both physical and emotional, psychological. We touch on themes of privacy. We touch on themes of boundaries and boundary violations. We touch on identity and personhood. What is the extent to which sexuality defines a person's identity or personhood, and are there other aspects of endeavor and initiative, whether it is studenthood or whether it is career, that also defines a person. We speak about issues like time management. We speak about issues like the legitimacy of pleasure and eroticism, as long as there is this framework within which. So the message is not to moralize or to delegitimize sexuality, but to place it in what we call as a happy, healthy, and responsible sexuality.
What I'm just trying to say is that suppose somebody wants counseling, adult or an adolescent, do we have?
There are increasingly the mental health facility all over the country has services for this kind of
sexual disorders,
oh,
sexual,
yes.
not sexual counseling.
Yes.
Call it as.
Yes.
So they have to go to
A mental health professional.
mental health professional. You want to tell them?
When we are talking about consent, there is still a lot of confusion when we are talking about consent, especially under POCSO. Because what the government says that the consent should be taken as a part, very important. Up to the age 12, they say you have to take a consent of parent. And from 12 to 18, the consent of the victim is important. And that is true for everything, for the diagnosis, investigations, for the treatment, and other ways. And in between, any time, patient can withdraw the consent. And they have given a word, informed refusal for investigation and examination and for police information.
Right.
So these things are important for all the doctors to know and to follow all these things, or we can decide ourselves what is we should do when we are talking about consent and when we are talking about the informed refusal. Because this becomes a very important thing most of the time when we are talking about the social issues. That means that we have to tell them that this is our responsibility and we have taken informed refusal from them, they don't want anything.
Right. Doctor, I believe that even for POCSO, I believe that POCSO is a work in progress.
Yeah, that's true.
A law is not carved in stone. It has a history and a basis to it, which is strong and legitimate. You execute it. There are elements of it which work very well. There are elements of it which are problematic. And then it goes for amendments. Just as the Juvenile Justice Act itself has been amended in 2012, which speaks of the whole issue of the transfer system of children in conflict with the law. Of course, that's not the theme of what we're discussing, but I'm just saying that amendments are always possible. There's also a difference between consent and assent. And in research with children, we usually speak about something known as assent, a child's assent. So I look at this as a work in progress. And it is not that there was an enormous amount of experience of these processes that was collated at the time that the law was framed. And it is now that the law has been framed that in the experiencing of it, people encounter difficulties or bottlenecks. And as we gather those experiences, we take them back to the law-making agencies. And coming back to the point that Dr. Agarwal was making about where INA positions itself in advocating for what is a fair and a sensitive approach and a recommendation that comes from the medical fraternity to make the lives of children easy. These would be strong and I think exceedingly critical processes. It also demonstrates to me that medical practice is not restricted to clinics and hospitals and medical colleges. The landscape of medical practice has gone much beyond that. And what is the relationship of a doctor with the social systems like the police and the judiciary and law making that? And child sexual abuse, as you rightly pointed out in your sutra, is one of those things that covers this wide canvas of people from education, from activism, from media, from the judiciary, from police, from the health sector.
So what I'm going to now do is, I'm going to come back to the last couple of questions. My first thing is what IMA should do in talking about CSA. At least, whatever the things that you feel that IMA should take it up, either they are deficient in law, wrong in law, or awareness. And second is, what are the 10 points which every doctor must know? I'm not talking about even a GP, whether cardiologist, orthopedician, gynecologist, anybody. So what are those 10 points which every doctor must know about child sexual abuse? The first is what is the role of IMA? Apart from sensitization of those 10 points.
I look at IMA's role.
But before that, are you an IMA member?
I believe I am not.
You are not. So just before we go, just go down and make him from our side. We will make him a member. This will be our courtesy. We'll make him a member of IMA. We'll pay for that.
Thank you very much for your kindness. This is not in any order of importance, but IMA functions much beyond the jurisdiction of medical governance and policy and so on. IMA concerns itself with education as well. What is the extent to which through IMA's persuasion child sexual abuse is tabled in the medical fraternity as a major issue for sensitization? This is not just about medical colleges during the pediatrics posting or in pediatrics training to know about child sexual abuse, that but for IMA to mandate through its let's say its postgraduate program or any such program that IMA runs to table it not just as information, but beyond information as an area for the medical fraternity to understand, and so dissemination through the IMA sources. That second is that for any issue of the nature of child sexual abuse that carries with it the multiplicity of important issues. It's an issue that concerns children. It's an issue that concerns trauma. These carry a certain weight or a certain valence which render it that much more serious. I'm not saying other medical conditions and other age groups and the problems they face are not serious, but when it concerns children and abuse, it attains a certain weightage that in order for the seriousness of that valence to be recognized in the medical fraternity, the issues around CSA need to be understood on campaign mode. So that's the next step that one takes it through. The third issue is that all the initiatives that medical fraternity and people interested in the areas are taking across the country. For example, the idea of a one-stop trauma center for any kind of trauma or any kind of even violence against women, for that matter. Could there be a recommendation and guidelines from IMA as to how this should be set up, who should be operating it, what should be the kind of training that they have, to come as a representation from an august body such as the Indian Medical Association goes a long way in giving this issue the importance that it deserves. The next level is basically assisting those within the medical fraternity who are working on the area in a deeper and in a more enduring way, assisting them in basically strengthening the recommendations that are made for policy change or for law change or for processes. So IMA takes it up as an agenda to basically strengthen the...
I'll come back to 10 points which every doctor must.
Right. Number one, believe that child sexual abuse takes place. If you do not believe it, then you will not be able to diagnose.
Believe that it's common.
Second, to be able to know the signs and symptoms and therefore have an index of suspicion. I just want to give a small example. If a child comes with some behavior which we know is stress related, that the child seems to be afraid to go to school, we have no difficulty in asking questions like, are you having trouble with any subject? Are you afraid of the exams? Did something happen in school? Is everything okay at home? But we do not ask the additional question to say, did anything untoward happen? Did anything uncomfortable happen? Did something happen that made you feel uncomfortable? Did anyone do anything to hurt you? Or so there is a way in which questioning can be done, and to learn this, the art of sensitive inquiry. The third is to know all the referral sources to who are the people who are working in this area, NGOs, lawyers, activists, childcare agencies. Fourth, to know the law well, especially some of the significant provisions in the law as they pertain to the medical fraternity. Fifth, to be aware that healing does not necessarily occur only with the psychiatrist. Even a pediatrician or a gynecologist who needs to give an opinion on, let's say, physical evidence can
even MBBS can give you a
healing touch. Next, how to be reassuring to families who are themselves undergoing a lot of turmoil. And how many have I covered?
It doesn't have to be 10. Good.
I'm just kidding. I thought I'd covered 8. Anyway, the next is to be uncompromising and non-negotiable and ethical in your documentation. Documentation is very, very critical to accurate documentation. So that's a non-negotiable, and one must be uncompromising on accurate documentation. The next is to keep in touch with cases that are going on and how the media and how the public perceive. So wherever you look at misconceptions on child sexual abuse, you're able to correct those and understand it. And finally, I think the medical profession needs to take a clear position to come back, therefore, Dr. Saab, to the sutra with which you had started, which spoke about, child sexual abuse, how common it is, when it is suspected and confirmed, how it's an acute medical legal emergency. That kind of describes the context in which it takes place. The one thing that sutra misses is what I would like to end with, which is for the medical fraternity to take a position that they would take a stand and a position regarding child sexual abuse, that if and when, either directly or indirectly, that they come across a case, that they would take a stand on it. Because just to quote Reverend Desmond Tutu, if an elephant has its foot on the tail of a mouse and you call yourself neutral, the mouse will not appreciate your neutrality.
Okay. You have to take a stand. So I'm going to come back to the last issue. And my last issue is sexual preferences, sexual behaviors, sexual orientation in a child. Propose, and that is another cause of going into a guilt. The child feels that his orientation is male to a male, female to a female, and that starts much before 18. How to handle that? I'm just delinking with CSA.
Yes, I know. It's a very important issue. I'm glad you asked this question because I have had the privilege to work with the lesbian, gay, bisexual and transgender population and assist them in their struggle and their right for access to mainstream health, as well as their right for inclusion and not to be misunderstood or victimized. We need to understand, Dr. Saab, that civil society is constructed on the basis of patriarchy, heterosexism and homophobia. And this is a deadly combination, because where we believe that heterosexuality is the norm, we are in a problem. And in fact, many of us have taken a stand on Section 377 of IPC and have filed affidavits in the Supreme Court after the judgment of the Delhi High Court, which actually read the act down, but then it was reinstated. We have filed 2 affidavits in the Supreme Court that many families find it very difficult to reconcile themselves because they themselves are socialized to believe that heterosexuality is the norm. And we grow up with homophobia and transphobia. So it's a question of persuading again and working with the families after we confirm true sexual identity and sexual orientation issues, to get them to recognize the personhood of the child, and this is only one aspect of the childhood. And the younger the child, the more difficult it is, because there are always issues like he'll grow out of it. Perhaps somebody has changed his mind by influencing him, and there are all these kind of explanations that, but most of them arise because of people being socialized believing that heterosexism is the norm. So patriarchy, heterosexism and homophobia is a pernicious combination, and that's what we need to combat when we work with families, to reassure them and respect the true identity of who the child is.
So that comes to an end. So child sexual abuse, evident or suspect, is common, preventable, punishable, acute medical legal emergency. Believe, as a doctor, you must believe that it's common. You must understand a high degree, you must practice high degree of suspicion for the signs and symptoms. You must look for a stressful behavior in a child less than 18 years of age. You must understand and keep all ready reference sources to be ready with you. You must have a list where to send such a child, and you should know the law well. You should know the POCSO, you should know the IPC, and you must know that everybody. You can't say that I'm not a pediatrician or I'm not a psychiatrist, I'm not going to handle. You need to handle the child psychology, and you need to reassure the family, and you need to reassure the child and the counseling. And you must remember that documentation is non-negotiable. Don't compromise on negotiation with that, and wherever you find a time to talk, wherever you give a slide, whenever you are talking to the media, try to include and try to remove the misconceptions. And remember, in media, you're not supposed to disclose the name of the child or of the family, and you must treat the incident sensitively and not sensationally. And remember, the sutra we have given you, every doctor must remember. Myself, Dr. K.K. Agarwal, and my colleague, Dr. R. Tandon, we say thanks to our guest, Dr. Shekhar Seshadri, and this video will be available on our email website for the next 1 year. And we take it to say goodbye to you. We'll be back on Thursday with another topic. Till that, goodbye.